All right, Mr. Chair, we're live on YouTube, so whenever you'd like to start, go ahead.
Okay. Good afternoon. Due to COVID-19, Committee of Adjustment public hearings are being conducted virtually by electronic means through WebEx Webinar, an online digital platform, and streamed on the Toronto City Planning YouTube channel. Participants who have registered in advance will be able to make their presentations to the committee using WebEx Webinar, which is moderated by city staff. Anyone wishing to view the hearing may watch on YouTube. Participants who have registered in advance will be connecting with their computer, tablet, smartphone, or telephone and have the option of participating via video or audio only. All participants will automatically be muted on entry, and when your item is called, each participant will be unmuted by the moderator, one person at a time. We also ask that you mute your devices until you are called on to speak. Those participating by video appearance will be temporarily upgraded to panelists when your item is being held. During this time, your camera will be enabled. You will only be visible during your 5-minute allotted speaking time. At all other times, your video will be disabled and you will be reinstated as an attendee. Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Members of the public and applicants are not allowed to use share screen or any other panelist controls during a video appearance. The host will remove you from the panelist role if you fail to respect this instruction. Land acknowledgement. We acknowledge that the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. In accordance with sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning that apply to the property, permissions to extend or alter lawful non-conforming uses, and consents to sever properties to create new lots. Anyone in attendance today who wants to receive a copy of the decision of the committee on an application must submit a written request for a decision by email. Please ensure that you include your name, address, and email address, because the Committee of Adjustment and the Toronto Local Appeal Body, in the event of an appeal, will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee, you may be able to appeal the decision to the Ontario Local Appeal Body, or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government recently amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. As of November 28, 2022, only the applicant, the Minister of Municipal Affairs and Housing, specified persons and public bodies, as those terms are defined in the Planning Act, are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. The hearing procedure is as follows. Call each item in the order listed in the agenda for this afternoon. So I believe that starts at item number 19. And going through in order, when an application is uncontested, the agent or applicant may proceed with a presentation if they desire. Where the committee does not require presentation, the applicant is to advise the chair should they wish to address the committee, and the committee may ask questions and then take the matter into this committee for a decision. Each speaker, including either the applicant or agent, will be given a maximum of 5 minutes to address the committee, and the clock is up in the room showing when you are approaching the 5-minute mark, and we'll ask you to wrap up. When addressing the committee, please start off by clearly stating your name and address, and please remember to confine your remarks to the matters outlined in the application. We deal with planning issues pursuant to sections 45 and 53 of the Planning Act, and that's all we deal with. The applicant or agent will proceed first in a contested application where there's someone else wishing to make submissions, and they make their presentation first. Please note that the committee may not entertain revisions made to proposals at the hearing today. The committee may decide to defer the application if being substantially revised to ensure that the revised application is accurate and that all those entitled to notice of the application have been informed of the changes. Then parties, individuals either in support or opposed to the application will be permitted to speak. Committee members may ask questions of each speaker after they finish their presentations. When all speakers have finished, the applicant or agent has an opportunity to rebut only those issues that were raised by the speakers. That will then mark the end of the discussion, and the application is then taken into committee for a decision. Are there any declarations of interest or panel or staff for the items in this afternoon's time slot? Ms. McCluskey, I think you're one of the deferred items you were previously had a conflict on.
Exactly, yeah, item 23.
Okay, so I guess any others? Anyone else have any other conflicts of interest to declare on this afternoon's items? I believe I may have forgotten to ask that question this morning, but I assume if anyone did, they would have advised.
Nishi,
Okay.
can you state the reason again for this hearing?
Yes, it's a friend and former colleague.
Okay. So, okay, deferral request. Madam Secretary, look, we didn't get that memo, but it looks like item 19, the first one off. We have a March 3rd email from the agent wanting to defer to April the 27th. There were examiner's notice now requires a parking variance for 2 cars. So I guess they have a notice issue. This was to legalize and maintain an existing triplex with 8 variances. So I trust it should not be put off too far in the future, since it is a legalize and maintain rather than something yet to be built. So is April 27th available? Well, let's see who actually let's call, see who the agent is on this. I assume they're here. Yeah, Christopher, it was supposed to be Mark Kemmerer. We were just advised that someone named Christopher is going to be speaking.
Yes, good afternoon, Mr. Chair, and good afternoon, committee members.
Good afternoon.
And you're correct. I understand it's been agreed that this matter be deferred to April 27th for the reason you've just stated.
Can you start off and let me know your name, please, especially since you're not the speaker on my speakers list? It's Christopher something?
Christopher Statham, Mr. Chair.
Okay. And staff, you have the spelling of that?
Yes,
I
Mr.
assume
Chair.
it's the same Fry law, same information. Okay. So the this matter is going to be deferred to the April 27th date.
Yes, thank you, Mr. Chair.
Yeah, and that's for the reason.
I'm not confirming April 27th. Staff will confirm that once they have everything they need from you. It is still available, though.
Okay. It should be as soon as possible since it's a legalized and maintained. So I don't know if anything's available sooner, but okay. So members, any questions for the agent, or is someone ready to make a motion?
Move for deferral to correct the notice.
Okay, thank you, Mr. Kumar. I couldn't
Second.
see the visual there. Seconded by Ms. McCluskey. Thank you. All in favor? Okay, the matter is deferred. We'll see you back here again in April when it's a little warmer out.
Thank you.
Thank you. Okay, our next application is item number 20, and that is 2190 Dufferin Street. It's an application to convert the existing ancillary structure into a garden suite. And there are 11 variances. This matter was deferred. We're into deferrals now for the rest of the afternoon, I think, other than the last item. This was deferred from August the 9th, 2018. And we have material from the previous hearing after the dust has been knocked off. And we have a planning email that they have no concerns. So this is quite interesting. The speaker, Jonathan Benkowski. So Mr. Benkowski, this could be one of the first garden suites we approve at this Etobicoke York panel.
So I was hoping to have it approved in 2018, but apparently that was 5 years premature.
So what happened with this one? I guess the committee, it seems like all the applications were, as I tended to expect, that there are going to be a lot of growing pains in terms of people trying to get too much into this garden suite situation and not being able to comply with the performance standards. But you seems with 11 variances, you seem to have satisfied planning. So please,
Yeah.
It's just
Mr.
2
Chair,
minutes.
Jonathan Minskowski, 301 Keewatin Avenue. This is entirely an existing structure. There's actually nothing proposed except for a change of the roof line. Largely these variances are due to the actual site has two completely different grades. So if you want me to get into a presentation, I'm happy to. We have worked with planning over the years.
Okay, so this is something that's already built, and it's a change of use. It already had plumbing. It already had plumbing and heating, and
correct. There is no OTC. There's nothing illegally built. This has been there, historical structure. We tried multiple ways to improve it and fix it up, but nonetheless, we are here today before the committee requesting for the garden suite. And if we would just go to maybe one of the elevations, I can kind of highlight the uniqueness of the site and kind of what is causing some of the deck, the projection variances that are before you. Yes, so we see there the actual site itself has two different distinct grades. If we look at the existing rear elevation, the left side there we see is actually at a completely separate grade than the raised portion. So this is a one-story structure as we see from the front elevation. It just appears as two stories as we go to the north based upon a retaining wall and a completely change of grade within the property itself. This is on the hilled portion of Dufferin, kind of as we go from St. Clair up until Eglinton, where we kind of get that winding hills. So, yeah, and I'm happy to answer any questions.
okay. Yeah, I'm very familiar with that topography, and that I've traveled along that many years, along that very stretch. So again, I thought we were approving. We should still yet that this committee to approve and add to be built garden suite. Do any of the members have any questions or?
I do have a couple of questions.
Okay.
Just
presentation's okay too.
with respect to variances 9 and 10, I mean, this is an existing structure that's been around for quite some time. I'm just wondering why bicycle parking cannot be provided.
We can provide the bicycle parking. I can withdraw number 10. That's not an issue.
And then the same question for number 9, why can't the screen be provided?
That's actually within the site itself. So if we do go to the site plan.
No, I know it overlooks the other half of the backyard. Basically.
Yeah, correct. Really internal to its own property that's there.
Right.
So it would really just be screening yourself.
I can understand that one. Yeah, I understand.
Yeah, so they may decide to do that, but it shouldn't be imposed as a condition.
Yeah, that's fine. That's fine. So
yeah, but I am happy through you, Mr. Chair, to remove variance number 10.
Okay.
Fine.
And then that just leads me to a curiosity question as to how this site came into being. It looks like it just a sliver of the south neighbor was removed at some point.
Yeah, through you, Mr. Chair. The topography and everything of this site is one of the more unique ones I've ever seen. As we see from the lot patterns of the north and to the south, you're 100% correct. It appears like the back triangle of the southern lot was removed. That historical structure at the back, we since basically 2018, we've been trying to repair this by trying to get orders to comply from the city, and basically just to say that it's unsafe so we can fix what's there. So it is a historical structure. It's a historical lot. And if we look, it largely could have been born out of the topography of what was there.
Yeah, now that makes sense, seeing the topography lines on the map.
Yeah, it's a very extreme slope.
Yeah.
Okay.
Okay, any other questions, or is someone ready here to make a motion?
I mean, I'm good to go with the motion since I've already got my mic open. So I would move approval for all variances with the exception of number 10 with no conditions.
Okay, thank you. Seconded for Mr. Komarik's motion. Mr. Palmer, thank you. All in favor? It's unanimous. You have your approval.
Thank you.
Have a good afternoon. Thanks. Okay, next application is item number 21, 3 Robin Hood Road. It's an application to construct a 2-story rear addition, a 2nd-story addition above the existing dwelling. And there are, this matter was deferred from April the 11th, 2022. Although in the minutes it says it was April 21st, 2022, so one of those needs to be corrected. This was was deferred to as additional materials. We have the minutes to deal with concerned neighbors. It's a two-story addition. I've already said that. 2 variances. We have the material from the previous hearing. We have a cover letter. There's something to deal with dealing with the rear deck variances, which are now eliminated. And we have 2 new variances. And we have an applicant's presentation and including renderings. Perhaps we can see that on the board as we hear from the speaker. There is only one, Sandra Gava, the agent for the applicant.
Good afternoon. Sandra
Welcome.
Gava here.
Okay, welcome. So I see you have some presentation materials. Perhaps we just put the rendering up and see if anyone has any questions. So what happened with there was an issue with the rear deck variances?
So our original committee application was a height of rear deck variance. We ended up eliminating that variance altogether, so that's why that one is gone. So this new application is asking for a small second-story addition, which is on a portion of the ground floor that is already there. So this, to give you a quick background, this home is already under construction. It's nearly completed. It was originally classified as a reno addition because we maintain 50% of the main walls. If you just scroll to the last rendering, I think it gives the best kind of illustration of what's going on. Yeah, if you wouldn't mind zooming out so you can see the before and after.
Or above it says current home under construction.
Yeah.
So it's the slide with, there we go.
Yes. So you can see there's an existing 1-story portion. And what we're doing is we're asking for a portion of the second floor to be built over that floor. So there is a side yard setback variance, but that is a bit deceiving because there's no further side yard setback to what is there now, and then a minor gross floor area increase.
Okay. Yeah, it's in line with the previous setback.
Yes.
Okay, does anyone have any questions for the agent, or is someone ready for a motion?
Yeah, I'm good to go with this.
Go ahead,
I mean,
Sam.
it's minor, it definitely meets the 4 tests. I'd like to move approval, no conditions.
Thank you. Seconder for that? Neil, thank you. All in favor? Unanimous approval. Thank you, Sandra Gava, and we'll see you again. Okay. Okay, item number 22. This matter was deferred from the June 9th, 2022 hearing for TETTENHALL Road. It's a detached dwelling, new one with an attached garage. There are 6 variances. We have the minutes from the last hearing in June. There were 9 variants, it looks like. The deferral was to deal with the consult with planning, and planning is recommending refusal of this application in their February 2023 memo. And that's all we have on this application. Speaker is, well, we have the revised plans and whatever. 05, oh, that was the previous information, I believe. Okay, the speaker is Michael Flynn. He's the only speaker on this application, agent for the applicant. Welcome, Mr. Flynn.
Thank you, Mr. Chairman. Good afternoon. There is one more item filed, or actually there's more than that, but there is a support, what's it called? I don't want to call it, it's a, anyways, there are 8 neighbors in support who have signed in support of this application. There are no objectors except for planning.
And that petition you're talking about is the one back in May. It looks like they're signed in May before this matter for the committee in June, right? Yes. And so there's now only 6 variances, not 9. Is that correct? That I said in my opening.
You're correct. Yes.
So they're okay with the 9. They're okay with the 6.
Yep.
Okay.
I also filed a chart that demonstrates the changes from the original to the present. And I think, well, I can just tell you what they are. The original variance number 5 had side yard setbacks, and the required is 2.4 meters. The original proposed was 1.7 and 1.82. The present one, as revised, is 1.8 on both sides. Building depth.
If you go to the planning report, they do a nice little summary of it on page 2 of their report, Mr. Page 3 of their report. It says building staff expressed concern, applicant has since revised, and the following changes were made. They're sitting right there for you.
You're right.
And they say...
Okay, well, then let me speak to the planning comments.
Yeah,
we are more... I'm sorry?
Yeah, go ahead. That's what I need you to do. They say it wasn't enough. Yeah, they say it wasn't enough. It's not enough. So you have to convince the members why this is worthy of support.
We are more than a little chagrined with planning department. We obviously we made a number of changes. We sent it in. I started calling planning 10 days ago. I am still waiting for a return call. So since my call to them, they have put in their comment, which I don't agree with. And I've spoken with the plans examiner, who deals with a number of interesting things here. One is that the building length, depth, whichever it is, includes the loggia at the back of the property. The examiner himself is not in agreement with that, but he says technically I have to put it in, so I am. But the actual length of the building is 18.77, which meets the bylaw at 19. But when you add in the loggia, you've got, and there's one more issue with that, and that is that we have the front setback further than the required. So when you're dealing with length, you are measuring from the required front yard setback to the rear wall. So you've got those two technicalities. One is where you start the measurement from and where you end the measurement. But the building itself is less than the required. So we don't think that that is an issue, and it shouldn't be for planning either. The other thing about all of that is the loggia's area is included in the FSI. And the reduction, if you deduct the loggia, is 0.04. So then the requested FSI becomes 0.49, which is pretty much in keeping with the general neighborhood. Height, the soffit height should not even be an issue anymore. The appeals of the new bylaw have been completed, and the former city bylaws have been deleted, so they are not enforceable anymore. There is no soffit height in the new bylaw. It was in the old bylaw. So that is in effect no longer valid. So all in all, I think we have what is actually a much more modest application than planning would have you believe. And it's well in keeping with the neighborhood. This neighborhood is a number of existing large homes with generally small setbacks. And I've gone and checked them myself, and they are, in fact, relatively small compared to many neighborhoods. And this application meets with them, or is in keeping with them. And that's, I would submit, the reason why we have 9 neighbors signing in support of this application, and none in opposition. So all in all, I would suggest to the committee that this is a good application, relatively modest compared to many of the homes in that neighborhood.
You're
And
at
the
the
other
end.
thing about side yard, I'm sorry.
Wrap up, sir. You've been wrapping up for the last minute, but just please wrap up finally.
Yeah, so I think that we meet the 4 tests. I think it's appropriate development. It's in keeping with the neighborhood. And it meets all of the tests, and I would ask the committee to approve.
Okay, thank you. Before I turn over to see if anyone else has any questions, I have a question. On a new build, see, one of the things is that your side setbacks, north and south, were revised from 1.78 and 1.82 to get this 1.8 on either side. So what did you do? You took a 2.2 of us moved from one side. So you gave nothing there. And one of the things the city says is that's completely out of context. It would be a lowest approved side yards at 1.8, which is no improvement from your previous June iteration. And we're 2.4. So you didn't move at all on that. So my question to you is, on a new build, why do you need 1.8 meter side yards? Isn't that a little?
Well, it's actually, it has to do with the garages and everything else.
My question was that a straight? Is that just for a little bump out somewhere and the rest of it is 2.4? Or is it 1 point all the way along? I haven't taken a look at your plan.
It's pretty much 1.8.
Okay, so why
it's
do you
not
have?
Because of a bump out, but it's an improvement over the existing circumstance. When they take down the existing house, which is a lesser number, they are actually improving the side yard setback.
You're saying the existing side yard setback, I don't know what's on a smaller house, obviously, is greater than it is what you're proposing at 1.8 on either side. You were to even it out for the two neighbors. That is appropriate, even though planning says it would be the lowest in the subject street, and it's a new build.
Well, it's interesting. Planning and I had not a debate, but a discussion on this, and planning has based their opinion on precedent. And as you know, and the members know, and I know, there is no such thing as precedent when it comes to minor variances. And I had that discussion with him, and I told him that he had no business using precedent to make his decision or form his opinion. Well, he didn't agree with me on that one. He also is not of the opinion that a zoning examiner has a right to voice an opinion, which I find entertaining, but I guess technically he's correct. So, you know, often what we do...
Michael, hold on a second.
Sorry.
You do have both adjacent neighbors, number 6 and number 8, that are first signatories of your petition back in May 2022. So they seem to be okay.
Yeah.
They're
fine.
Are those homes to be redeveloped? Are those new builds?
There's a cover letter from me on the AIC.
So
which
do you know
speaks to...
What do the side yards that number 6 and number 8 have? Because that's the only issue I had was the side yards.
Actually, I have no idea, but they're relatively short.
Yeah.
I would suggest they're not 2.4. So I would suggest that they are less than 2.4.
Yeah. I see.
And if they were building today, they would require minor variances.
Yeah. Okay, I'll turn it over to the other members to see if they have any questions or if they're ready for a motion. You didn't mention that in your presentation. Okay, thanks, Michael.
You're welcome.
Any questions for Mr. Flynn? And if no questions, is someone ready for a motion?
Yeah, I'm good with the motion, I think.
Okay.
Thanks for that question. That was going to be one of mine, and then the other one was I noticed that both of the immediate neighbors are in support, so I think that speaks a lot to this. I also noticed that the amount of the variance here for GFA is less than the one that we refused in the morning session. So just wanted to note that as well. I think I'm going to move a motion to approve. I believe it does meet the 4 tests. I would, however, like to tie it to the site plan with regards to the building depth. So we're not giving a blanket approval on that depth number. And I would like to make it conditional on forestry 2 and 3.
Okay, thank you, Mr. Komorek. We have a seconder for the motion.
Second.
Thank you, Michi. All in favor? Unanimous approval. Thank you, Mr. Flynn. Have a good day. Be well. Okay, item number 23 is 106 Celestine Drive, and it's an application to legalize and maintain a new detached dwelling with an attached garage. There is one variance before us, minimum side yard setback of 1.2. On the north side, it's 1.04. So the agent is M. Arshad Siddiqui. Welcome, sir. Agent for the applicant. Please explain, how did this happen?
Good afternoon, Chair and committee members. This is Arshad from C Architecture, Georgetown, Ontario.
Okay, just I didn't say at the outset, this matter was previously deferred from the February 9th, 2023 hearing in order to post the sign. And this is the application that Michi has her conflict, so she has left the room and will not participate. So that's it. It's a legalized maintain. We're talking, very small amount on the north side. So how did that pass?
Yeah, that is the only variance. It is due to the previous contractor construction mistakes of demolishing the exterior walls beyond what was allowed and pouring the foundation beyond the allowable setbacks. So then he left or absconded the site, and then owner had to deal with all the approvals and everything.
Right.
So this is something we will have to demolish a lot of foundation walls. So instead, minor variance is requested for 0.16 meter setback. And to mention one thing, that we agree with urban forestry condition of making the payment for cash in lieu of an existing street tree.
Okay. That was a condition.
That was sent to us as a memo for the address was categorized as number 3, and number 3 had a payment requirement for
payment in lieu. Okay, Madam Secretary Treasurer, you aware of what the agent is talking about? Barb, I think you may be muted.
Have condition 3. It's from urban forestry.
Okay, that's what okay, I see that here. Urban. So that's subject to that. Okay, any questions, members, or is someone ready to weigh in with a motion?
Yeah, just a question for the applicant. The reduced side yard setback, that's just for the garage and not the main dwelling. Is that correct?
That is correct, sir.
Okay, so would you be okay if we tied this for approval just to the garage?
Yes, that is fine.
Yeah.
Okay, thank you.
Thank you.
Yeah, that seems, very most appropriate. So is that your motion? A good segue plus urban forestry 3?
Well, subject to any other questions, yeah, I'll move for approval. The variance requested is minor in nature and meets the 4 tests in the Planning Act. So I will tie that to the site plan regarding the side yard setback applying only to the garage, and subject to forestry condition number 3.
Okay, thank you. Seconded. Thank you, Stan. All in favor? It's unanimous. Thank you. You have your approval.
Thank you.
Thank you. Okay, Michi can return. On to item number 24. This matter being deferred from the February 9, 2023 hearing, 84 Treeview Drive. This is to legalize and maintain the 2-story rear deck and balcony. Bear with me here. We have planning advised that they're in an email that they're January 27 report stands. We have 10 letters of support, 1 letter of opposition from the affected neighbor at 86. We have an order to comply back in August 2022. Planning is looking for a condition of approval of screening. And we have, like I said, we have 2 variances, or actually, where's the application? Yeah, 2 variances. So let me pull this up. Because I had a question. So the speaker on this, we have several speakers. We have the, it looks like we have the homeowners at 84. And then we have the neighbor at 86 and a neighbor at 1558 Queen Street East. So, yeah, we have only 2 variances on this, and I'll turn it over to the owners. You're going to be presenting this yourself. This was not, this was deferred for proper notice. That's why it was.
Mr. Chair, before we get into the presentation, I have a question for staff, if I may.
Yeah.
The deck is 230 square feet, which I believe is 21 square meters. And is that not a size issue and a variance required for a deck of over 4 square meters?
That's for a 2nd-story balcony is 4 meters.
Is this not coming off the 2nd story?
This is not a 2nd story. This is considered a deck. But I have another major issue is that when I read this, which I was going to ask the applicant, but I see it's not their agent, it's a homeowner. So I'm going to ask staff the question I was going to ask, and the homeowners, I can answer this as well, that I can't believe that this only results in those 2 small variances that are noted. So has this been gone to a review? And the question is both for staff and for either, I don't know, if Julia Veccarelli or Matthew Smagli, the 2 homeowners who are speaking here. I assume that they haven't retained an agent on this. Is that correct? Who's the speaker on this?
Mr. Chair, members, the speaker will be Matthew. They've requested to be on video, so I'm going to go ahead and make them a panelist now.
Okay.
Matthew, if you like, you are now able to start your video by clicking the Start Video button, and I'm going to go ahead and unmute you now. Go ahead, Matthew.
Hello. Hello, everyone. Can everyone hear me all right?
Yes, we can.
Hi.
Just want to hang on. I just wanted to, I gave my introduction of this, and we've seen the pictures and have the order to comply, and why this was deferred back in February, because it had to be the notice. But I just want staff, I think Mr. America is asking the same thing, or whether we have a full picture of the variances that are triggered by this deck and the area below, and soft landscaping and everything else. I'm just wondering who determined these 2 variances, and perhaps you can let us know, and then staff can also let us know, because I'm a little surprised that this would be the only 2 variances.
It's not surprising to us because the general aesthetic of the houses here all have large decks and even sword floor terraces. It really does fit in with the neighborhood. And also, we have a very large lot. For instance, there's 14 meters from the end of our deck to our backyard neighbor fence. So, so it really isn't as big in when you look at it, and the actual variance is just minor. The variance was determined. We had an on-site visit. We also hired an architect for consultation. We got a new survey done with the deck included, with extra evaluations. Sorry, I'm not pronounced that well.
Yeah.
And this is what the city came back with us as being the variances.
Yeah, the city is saying all they seem to feel is a 1.5 meter privacy deck. I was, anyway, if you can give us a short presentation. When I looked at the plan, it looked like that none of the other neighbors have something similar, and it does extend pretty far back past the walls of the house.
Yeah. Would you like me to jump into
the
presentation?
I don't know about the members, whether we want to see a presentation.
Yeah. Well, firstly, thank you, Chairman and Committee, for letting us speak today. I'm Matthew Sparnaga. My wife is with me, Julia Veccarelli. We own the house at 84 Treeview Drive. We're the original owners. and we're speaking into regards of legalizing and maintaining a real two-story deck balcony. Now, as noted, the permit has two minor issues by the zoning bylaws. The first is that the deck is only supposed to project 1.6 meters away from our house.
Right.
And our deck is projecting 2.71 meters, which is slightly over a meter difference. And when you consider the size of our lot in the backyard, this is a very minor variance. As I mentioned, at the end of our deck, there's still 14 meters between the end of our deck to our backyard fence. It's a good distance. The second issue is related to lot coverage maximum being 49%, where our proposal is 44.88%. This equates to only a 7 square meter difference. And notably, you guys had a 30-minute meeting on a 10 square meter variance, so this is less than that, which is again is considered like overall, for the size of our lot, this is a very minor variance. Now, there is a precedent set in our subdivision around the deck projections from house. The application A017122EYK on 51 Vaudeville Drive in Etobicoke. This is a semi-detached house in our subdivision that was part of the same Mattamy build as our 2018 home. The deck went out 2.1 meters against the 1.6 meter requirement and was approved by the Committee of Adjustment with no conditions. They notably have a much smaller lot than ours being about 80% bigger than those. Interestingly, also, is when Mattamy built our original decks, the deck of which we have extended, they originally built it at 1.9 meters from the house.
Oh.
So our current deck actually only goes out 0.8 meters further than that. Our new deck also, because we legally can have it wider against our house, there is no variance there. This really provides us a security for our family. We have a 3-story house, and on the top story, if the level of fire, we had no exit. Now we can go out of the primary bedroom onto that deck. And having 2 kids, you can imagine like being ready for that, feeling ready for that. Things do happen, and we sleep better knowing that this is there to help us. Now, within our file, it's you mentioned there's 10 letters of support. There's actually 17 letters of support. I did another count, which is really overwhelming. And,
Okay. Oh, Doug, sorry. There were 10 originally, and then were another 9 in the additional materials.
Yeah. So I counted this morning. It is closer to 17.
It doesn't go by the numbers. It doesn't look at the people directly affected. So thank you for the explanation. So what I got out of that is Mattamy originally did have a deck, and it was one slightly over what's permitted.
Yes.
And now you're basically just 3 feet, like a meter over what's permitted.
Yeah. The whole point. Yes. Yes.
Okay. So to me, it looked like you were more than that over. But the issue is, my comment on this, we're going to hear from the neighbors, is it seems like something that if everyone did it, and it's really good extra space for barbecuing, for sitting out, for enjoying the outdoors, and then having the covered area below. To me, how many people in this line of homes, like if everyone did it, then you're all getting more space. So, but there was a deck there. It was put in by the builder, and you just had them make it a little bigger.
We made it wider, firstly, so we extended it from across the house, and then we went out 0.8 meters further.
Okay, thank you for that. Members, anyone have any questions for Mr. Smnagel, or we can hear from the neighbors? Does anyone have any questions before we move over to hear from the neighbors? Okay, so the neighbor is 86 Treeview, who wrote the letter. I don't know if you're going to have who's going to be speaking, because we have 2 names listed. We can only have the 1 speaker. Connie or Edward?
Mr. Chair, we have Edward on the line. You'll note, though, on our participant list that Nolan Naddle is representing 86 Treeview, so it may actually be Nolan. We'll have them confirm, though, now.
Oh, I was going to asking who that was going to. I didn't see that note on the side. Yes, it's right. So they're having a representative.
Mr. Chair, also noted that the area resident wants to be on camera, so I've gone ahead and I've moved them. I've moved them to. Mr. Chair, one moment, please. Mr. Chair, I've moved them to a presenter. So Nolan or Edward, you're able to turn your camera on now. I'm going to go ahead and unmute you now.
Do you see the camera?
Not yet, please.
Here we are.
We do now.
Okay. Hi, I'm Ed Moylam. I'm the homeowner at 86 Treeview. I'm here with Nolan Natali. He's an old friend of mine and an architect, and I asked him to speak on my behalf.
Okay, so he's the speaker then. Thank you. You push the camera over to him, so we only see Mr. Moy, and you're the representative.
Okay.
Good afternoon. So I've seen the letter. If you can please go through it. It seemed to me, so basically, I think it's basically an extra 3-meter protrusion further out. And the neighbor is agreeing to put up a privacy screen, and that's the recommendation of community planning. So please advise why that is, not acceptable, and what your client's position is.
Well, that's what, again, thank you, committee. Again, I'm Nolan Natali. That's basically what our letter was intended to do, was to illustrate how what seems to be small grievances, small variances with the zoning bylaw are actually fairly significant to neighbors and the street. And we looked at the 3 issues that we picked out that significantly affect, our Ed's property.
Mm-hmm.
Our overview, the effect on sunlight, and the use. With the overlook, you can see if okay, I see we have our letter up. From the balcony that is now, I was going to say, well, it's constructed already without approvals. Here it is. And from that balcony, you can basically see right through Ed's house, the next door neighbor.
Okay.
And that's the view into the interior.
Yeah, sir, can I just interrupt you one moment there?
Yes.
Just want to remind you that here at Committee of Adjustment, our obligation, we're only looking at the amount and the variance. So while I may agree with you, it's a big honking deck, and it looks back like everyone else. Back and can, if they want to, look back into the house, at their house, at the next door house. That all we're looking at is the extra 1 meter. So you have to convince this committee that, if not for that 1 meter, everything would be fine. You know what I'm saying?
Yes, I do.
The same overlook, I guess it's a little worse than you would tell me. But if you already got the overlook with what's permitted as of right, we can't permit what's permitted as of right.
This is not permitted as of right.
No, it's not. Everything is other than the extra 1 meter in depth.
Yes.
That's what I want you to tell me. Okay. How that extra meter affects your friend Ed. Not the whole deck, just how that extra meter.
Well, the extra meter is affecting our sense of privacy and enjoyment and our reasonable expectations for those when the house was constructed and when Ed purchased the home. When the deck is not there, this condition doesn't occur. And the Committee of Adjustment is supposed to make a decision on the compliance with, 4 criteria that we all know. And what we're trying to get to is the point where does it meet with the general intent and purposes of the official zoning bylaw and the zoning bylaw amendment. And to establish that, you have to kind of understand from our point of view how it is affecting our reasonable expectations for privacy, security, enjoyment, basically. And this is having a big effect on how these decks are affecting all the people's backyards. You can see even from the applicant's photos when he looks across and into the backyards of everyone. There is full exposure. Now, you are correct in saying this is not actually a cause of the 1.7 meter extension, but when the properties were built, every house, if it's possible to refer to the applicant's photographs in his supporting documents that show the backyard, you can see basically the size of the decks that were existing when the properties were constructed. Those decks were located in a fashion where, yes, you could be on the deck and overlook these properties, but the use was basically restricted by their size, so that you could reasonably expect that on these smaller decks, you could have a barbecue, you could maybe have a few chairs and things like that, and the use is easily anticipated. When it becomes the size of a living room, the use changes. And now that use, rather than periodic throughout the day, whatever, becomes the possibility for full-time access and occupancy, because it's there because the owner wants to enjoy the backyard. But this now imposes that it's an imposition on all of the neighbors, because now it creates an uncomfortable situation for them to even occupy their own backyards without being overlooked by an activity that is potentially going on all day long. Not only that, from the owner's point of view, he's actually on display. It's like a display that this did not occur and was not the condition that people who purchased homes on that street could reasonably anticipate having. Now they are either spectators or participants in activities that aren't part of their routine. This is where it affects the general intent of the official plan, because underlying the official plan.
Sir, if you can wrap up your 5 minutes.
Okay. I was going to say, under the intent of the official plan are all of the values that direct the official plan to be able to make decisions on development. The official plan is trying to outline those to create communities and neighborhoods. And the respect of your neighbors is fundamental and underlying that. And that, for those reasons, we don't think it's minor, and we don't think it meets the general intent of the zoning bylaw or the official plan.
Okay, thanks so much. Does anyone have any questions for Mr. Natali?
Yeah, question. Did you see the comments from Planning Department?
Yes, we did. And the comments were, suggesting that a 1.5 meter screen would rectify the situation, we don't think is fair. First of all, 1.5 meters is really just an average eye level height that architects use all the time. So it doesn't really prevent an overlooked situation. If you made it higher, if you made it 2 meters, then it starts to affect sunlight. So, all you have to do is look at the photographs to see what Ed is looking at. And you can see we did a calculation, built a little model to show that, a screen just increases our time in shadow basically during the day for, several hours. And it might allow us, or it might allow Ed to not have curtains on his windows all the time, but it means that he will look out at this screen all the time. So either way, it affects our sunlight, and we don't think it's an appropriate solution. The appropriate solution.
I think you've answered the question. Thank you.
Okay. Okay, any other questions for the neighbor's rep? If not, we'll go back to Matthew for a rebuttal. And Matthew, just let me know, I pointed out that it's basically you've gone a meter further out than you should. What's the total in, I guess I know that answer. It's right in what the variance is. So you're going out an extra meter. If there was a drawing on the board, I wanted it to look like there were 2 fence sections. It's maybe about half a fence section or not even. Because each of those 5 sections are 4 feet sections?
I'm not sure exactly, but Eddie actually has a second floor deck himself, closer to our house than ours is to his house. And
Yeah.
our deck goes out about 0.9 or 0.8 meters further than his deck does.
Okay, so does have a deck, the one that was provided by Mattamy.
Yes.
And we don't have a picture of that, though. No one's shown us that.
It should be in our initial submitted images.
Okay. Okay. So again,
I-
what I was just trying to show, and your rebuttal is, we're only looking at that extra 1 meter further out that you're going, which you're allowed, permitted as of right.
Yep.
No complaint about. So we have to show it's that extra incremental amount causing all the fuss.
Yeah, yeah, and I'm in total agreement. Well, I do not think any of these objections are materially impacted by the actual variance, and I'd like to speak to a few of them.
Okay.
And firstly, I'd like everyone to know that I walked Eddie through this deck weeks before the build, seeking any concerns he had. I talked about the dimensions and the layout. At that time, no concerns were expressed, but of course, seeing it might be a totally different experience, and I can understand that.
For sure.
Now, so starting from the top, so I'm just pulling up this thing. The explanation of like our deck does fit the general aesthetic and character of our neighborhood. Our photos submitted can show terraces on third floors. Eddie himself also has a third floor balcony, so they're concerned about our deck looking into other backyards. Not only do they have a similar view from their deck, but they also has a third floor balcony that Eddie can stand up and absorb all the backyards he wants to. Now, furthermore, from photo one, you can see from photo one of the objection, you can clearly see that view will not be impacted by the actual variance. The photo actually cuts off the variance. So with the variance gone, the concern is still there. The second photo beside it is, I guess, what they think the view might be. I would actually say this goes as far as at least misrepresenting the actual situation as far as fabricating. They annotate this is the neighbor's view from their deck into my living room. It's clearly just a photo that someone took from inside the house. The photo from our deck is much different, and I've invited Eddie in the past to come on my deck and take a look. Looking at my other comments, so I'm not used to speaking. I'm a software developer, so code is my.
You're doing a great job.
Photo 3 once again does not speak to the variance whatsoever. It illustrates that the deck concern they are claiming is mirrored to our deck. You can see the second floor deck above. We can see a very similar view, minus less than a meter from our house. I also think some of these objections kind of lead to some insinuating that like we're going to be watching them. We're happy to put up a privacy fence, and not because it's legally suggested or whatnot, because we just want to be a good neighbor. We want neighbors to be happy in their house. It's very evident from the 17 community referrals we received, in which it's worth noting we only canvassed one of those, and that is the neighbors to the south of us, directly south. And he signed happily. The other 16, a lot of them reached out to us, told each other, and a lot of them came in after they saw this objection because they really felt it was wrong. Once again, nothing here speaks to the actual variances. The usage of the deck, I think, is also like thinking that like we're going to be out on the deck all the time. I think there was mention that it was constructed to mirror our inner living room, which is fabricated again. We have the same model house. The deck is about half the size of our living room. And to imply that's going to be used as an interior space, I think is an extreme exaggeration. Doesn't speak to the variance. And I don't know anyone who can use their deck more than 3-4 months in Canada. I think we had dinner out there twice last year.
Yeah. It's a valid point. If something is bigger, you can get more on it. But I think even without I look at that 3 feet 1 meter section.
Yeah.
And I don't think you get an extra 1 share on.
Yeah.
It is what it is. So the issue, but it was a good thought.
Yeah.
I don't fault him, but the question is whether it's minor. So yeah. So if you can just wrap up and we can.
Include nothing of this speaks to the actual variance and how that can materially impact our neighbors. None of our no other backyard neighbors have submitted objections, including the neighbors behind us. I've talked to a few of them, and two of them went out of their way to come by the house and tell us the deck looks great. And two more sentences. It is real that this proposal doesn't outline that he has his own deck and his own third floor balcony that has a much greater viewpoint. I think that speaks to kind of the character of this letter of rejection. And we have overwhelming community support. Go ahead. Sorry.
Other people have said you can see this, so it's not just the people; it's everyone around can see this also. If that's the argument, I have a question: are there stairs coming down off the deck to bring it down to ground level?
No, and notably, we never plan to do that.
Okay, thank you. Let's see if any of the members have questions either for you, Matthew, or for Nolan. And otherwise, I'll take it into committee for its decision. Mr. Kumar?
Yeah, a question for the neighbor. Are we to gather that if we were to approve this, your preference would be for there not to be a privacy screen? Just want to get that clarified.
Mr. Natali, are you listening?
Yes, I'm here.
Yeah.
Yes.
Good question, actually.
Okay. Should I address? Yeah. Yes. If there's a privacy screen, we'd like to, be assured that there would be some, design intent, that it's not just simply a piece of the fence from the ground floor up there. And it would need to be taller than 1.5 meters. So, because many people can see over it. So I would suggest maybe 1.8, 2 meters.
That's the city standard for screening on decks, and usually it's something. So your clause, Mr. No, something came up that I was going to ask you about. So your Edward, Mr. Mulliam, he has a fourth floor deck, like a balcony.
No.
Yeah, it's
he has a balcony.
1/4 the size.
I realize that. So Jewel, up there, it's not a big balcony, but it would still give you a bird's eye view to look, like if anyone, looking down on the other neighbors as well.
Yes.
Is that correct?
That's true. But
we hope that most people they're not looking around going to peer into other people's houses, because you're right, in theory, it can happen. It can happen with the legal deck projection. It can happen with the legal deck projection and an extra meter. So that's the issue. We just hope that people, that's not their intent. They just want some fresh air. We have 4 or 5 months we can go outside in this country, and they want to be able to have a barbecue and get some fresh air on an outside space that is off their main living space.
Okay, can I just get a clarification? Rather than, I don't want to get into a negotiation on what the privacy screen should be. I just want to get a clarification on the preference for yes or no on the privacy screen.
Yes.
Thank you.
Okay, exactly. Okay, any other questions, or is someone ready for a motion?
I'd just like to include.
We're in committee now, so only if someone asks your question, we're sort of out of the back and forth. You had your rebuttal, and you had your full 5 minutes. So if someone asks your question, but I will see if we're done or not. Unless,
just coming back to what is a deck versus a balcony. I understand that a deck off the ground floor does not constitute a balcony, but I thought the bylaw spoke to the distance from grade, and that's why I thought this did constitute a platform rather than a deck. But if I can get staff to clarify that.
So this area, there was a subdivision done. So this is subject to a 2016 bylaw where the house is
right.
So they're not subject to the other provisions. They have their, and there was a zone.
It was a site specific. It was a zone specific thing. Okay.
Yeah. Mattamy built subdivision, I guess. So it was a standalone site specific bylaw. Okay, any further questions for either of the parties, or is someone ready for a motion?
No questions. I'm ready for a motion.
Okay.
Notwithstanding the objections of the neighbor, the variance requested, I believe, is minor in nature. The 2 variances requested, being that we're looking at coverage as well. So I will move for approval, subject to the planning condition. I just want to change it. In a planning condition, they refer to this as a 2nd-story rear yard deck, and I've been told that we should refer to these as platforms. So whichever is the correct terminology. The screening be added.
So just on the north and south sides, correct?
Correct. Yeah, but remember we had that one seminar thing, whatever, and I think staff said the bylaw actually calls it a platform and not a deck. Anyways, I know I'm splitting hairs there, but that's my motion.
And I guess it's on both sides, not just on the side of.
Yeah, it's on. They asked for it on the north and south side.
Okay, north and south planning. Okay, seconder for Mr. Palmer's motion. Rishi McCloskey, thank you. All in favor? It's unanimous. You have your approval. Thank you, Mr. Spinagle, and thank you to Mr. Natali for your presentations. Okay, and hope everyone does well. Okay, next application is item 2534 Doddington Drive. It's an application. Sorry. Yes, it is Doddington Drive. There it is. It's a 2nd-story addition above the existing dwelling, a 2-story rear addition with an attached garage. There were 6 variances, and now 5. We have the revised, highlighted, shown on the screen. We have revised plans and waiver, cover letter. Planning is would like the variance 3 height modified, I believe. And we can hear from that from the applicant. In the additional materials, we have the minutes from the last matter when this matter was deferred from January 26th. In order to consult with planning and the neighbors, urban forestry. We have urban forestry requesting condition number 1, and we have an arborist report as well. Okay, so
Mr. Chairman, I believe the revisions are as per planning's request. So variance 3 has been eliminated.
Okay.
Mr. Chair and members.
My note said, okay, modify the height.
Mr. Chair, members, the speaker wants to be on video, so I'm going to go ahead and move them to a panelist.
Okay.
Jennifer, now that you're a panelist, you'll be able to turn your video on by clicking the Start Video button. I'm going to go ahead and unmute you now.
Okay, and this is the applicant.
Property owner, to be exact, but yes. Jennifer, go ahead.
Oh, I'm sorry. I didn't know I was supposed to talk to you today. I thought it was going to be an architect talking to you guys.
Mr. Chair and members, I don't have an architect on my list of attendees.
Oh, sorry. No, I thought I was just going to be attending. I didn't know I was supposed to speak to
the Cortez.
Yeah.
He was here this morning. Another matter, I believe. So, and this is
Fausto Cortez is on the list of people in the attendees here.
Not on this application, though.
Mr. Chair and members,
He's
I've gone ahead.
He's listed as
I've
the
gone
agent.
ahead and unmuted Fausto.
Yes, but she registered.
Hello,
He is?
committee. How
Okay.
are you?
Good.
Good. Glad to be back this afternoon. Thank you for having me.
Okay. Yeah, for some reason, we didn't have you listed as a speaker. We only had your client, the homeowner, registered. But okay, so I just did the introduction. You're the speaker. You have those variances. So what happened since this matter was deferred back in January?
Thank you, committee. So since it's been was deferred, we spoke to planning. We modified the application to eliminate some of the variances. We spoke to forestry. We hired an arborist. We dealt with all the forestry issues with the tree at the front of the home. Forestry is now satisfied with the application. We are not in any way damaging the existing tree. The existing driveway and condition of the driveway adjacent to the tree will be maintained, and therefore the tree will not be damaged in any way. We've eliminated variance number 3 for soft rear yard landscaping, and we've improved variance number 4 from 8.44 meters to 8.2 meters. And we also had numerous meetings with committee members, with planning members, and we went through all the applications in the area that met exactly or very similar to the application that we're putting forth. Applications that are within 220 meters, 290 meters, 240 meters, 350 meters from this exact property. So planning was okay with our presentation to them, as well as with the revisions that we were proposing.
Okay, so basically your changes line up with what planning asked you to do.
Correct. As well as one other point, with obviously a few of these variances are as a result of the house being existing and us doing a modification to an existing dwelling.
Right. Okay. Any questions for someone, for Fausto, or someone ready for a motion?
Just for clarity, Mr. Cortez, in the future, you didn't register for either of your applications. Can you make sure you do that for your future applications? Thank you.
Appreciate it. Okay, I see Stan, you were about to weigh in.
Yes, Mr. Chair. I find the application to meet the 4 tests. I believe it's minor in nature. Would like to move approval as revised, subject to forestry condition 1.
Thank you. You have a seconder for that?
A second.
Thank you, Mishi. All in favor? You have unanimous approval. Thank you, Fausto. We'll see you again after you've registered. Okay. Item number 26 is 21 Lorraine Gardens. It's for a new detached dwelling with an attached garage with 5 variances. This matter was also deferred from the January 26, 2023 hearing. We have materials from the previous hearing. We have a planning memo looking for a condition of approval, 2 conditions. Forestry has no objection, I believe, or I'm looking for urban forestry condition 2. In the additional materials, we have the minutes, and that's basically what we have. The speaker on this application is Carol Jin, the agent for the applicant, as well as the neighbor next door at 23 Lorraine Gardens, subject to Adam advising that she's indeed on the line.
Mr. Chair and members, the area resident is present on the call at this time.
Okay, so let's hear first from the agent with respect to this new detached dwelling with 5 variances.
Hello, hi,
Yes.
member of committee. My name's Carol Jin. I'm the principal architect of Jin Architect. I'm here to representing my client, Al and Luciana Grilla. The proposed development is a 1-story, is a bungalow of over 6,000 square foot with attached garage and a walkout basement. Basically, the reason we ask for deferral is to work with the planning staff to improve the some of the issue, deal with some of the issues. So basically, the revised proposal, we have eliminated a couple of variances. One is being the height. We reduced the height from 9.86 meter to 9.5 meter. So now it's compliant with the zoning bylaw. And the other one is pedestrian entrance elevation. We reduced it from 1.31 meter to 1.2. So that variance is eliminated. eliminated. The main issue is the side yard setback. And the revised proposal basically reduced the side yard setback from 7.41 meter to 7.5 meter at the west, and increase the setback, and also increase the setback from 2.03 meter to 3.23 meter at the east.
Okay, so you made changes that planning requested. You're okay with the planning condition being recommended?
Yes, we're fine. Yeah.
Yeah. Okay, because you back onto the ravine, I take it, right? So they're
Yeah.
the windows to be bird friendly and dark sky compliant lighting, and tie it to your plans regarding the side yard setbacks. Okay, and I see there's urban forestry looking for condition 2, and then ravines looking for urban forestry condition 1. Is that correct?
Yes, we're fine.
Okay, and they have no objection. So let's hear from does anyone have any questions for the agent, Ms. Jin, or before we go to hear from the neighbor what her concerns are? Mr. Kumaric?
Just a curiosity question more than anything. With regards to variance 5, I just wanted to get an explanation on that. Is that because your dwelling is set so far back on the lot?
The variance 5, let me look at the you mean the proposed use is not permitted in open space natural zone?
Yeah, that.
That's just the existing house are already in the open space natural zone. The new proposal actually is approved that because it will pull the building further towards front, away from the open space natural zone. I think it has less impact now.
So is this a double lot?
Yes, it is the lot. It has been divided into 2. We got a consent approval a few years ago. I was the architect as well.
Okay.
And then my previous client sold a lot, 2 lots to my new client, and my new client now, current client, also owns both lots.
Okay, so right now this proposal is for which side, A or B?
B.
This is for B, and A has no property on it. It's going to be, there's nothing on A.
House, yeah. He's still planning to build it.
Very good. And the neighbor who's going to be speaking, she's at 23. So we're going to hear from the neighbor next. Okay, thank you. Any other questions? Stan, you have your answers? Okay, let's hear then from Linda Redan next door at 23.
Hi, ladies and gentlemen.
Good afternoon.
So it was just 2 concerns, really brief, is for number 1 and 3, which is pretty much the same thing. I know it doesn't affect me because I'm on the west side of the property, but Mr. Grella owns the large property that was severed into 2. So 21B is where the residence will be, and then 21A has the pool and some other buildings on there. So in the future, he might sell that, and he obviously might not keep it. And so with section 1 and 3, he's asking to be 4.23 meters closer to the property line, and obviously the eaves troughs will be much closer. And right now there isn't a person that lives there because he owns both properties right now. It's a very unique situation in our neighborhood. So my husband and I were just wondering, if this gets approved, it could set a precedent for the rest of the neighborhood that everybody can build extremely close to the property line. And the second thing isn't actually on the variances, but it's actually the west side of his property that connects to our property where the driveway is right now. So we have about maybe 40 to 50 cedars that are on our property that borders his, and he plans on building a fence which will damage all of our existing cedars right now. And the cedars, we've been told from other neighbors, were planted about 40 years ago. So they're about 25 feet tall. So what can we do when a gentleman does want to build a fence and damages our cedars and kills them.
Sorry, ma'am, that's not before us here today. I suggest speak to your lawyer or speak to the neighbor and to find out what your rights and obligations are with respect to your neighbor on the property line, but it's not with respect to the matters before us here today. We're not here.
Okay.
So we're here with respect to the build form in this application and the variances identified. So if you'd like to continue, you were mentioning the distance in terms of the roof eaves between the two 21A and 21B. That he's
That's correct.
And anything else?
Nope, that was everything. Thank you very much.
Okay. Members, any questions for the neighbor, Ms. Redan? And if not, we'll give it back to Ms. Jin to respond to the concerns raised.
Hello? Yes, I can respond to the setbacks. In this property is very large property. The coverage we're getting is under 20%. And we have a setback 7.5 meter on the toward at the west and 3.25 meter for a portion of the building and then 4 meter for the portion of the building at the east. We felt like I think it's a setback is very large to afford a privacy and it's basically it's compatible with the character of the massing and designs is compatible with neighborhood.
Okay, thank you.
And also my client owns both property. He plans to he has no plan to sell it. He's planning to make it a family home. It's a custom home basically.
Okay, well, it's a separate lot. It can be a house certainly at some point in the future. We look at, we're building here, we're planning for the future. So that's in and of itself. But thank you for your answer. Anything else you'd like to respond to what you had to say, or that's it? Okay. Any questions, members, for either Ms. Jin, the agent, or the neighbor, or is someone ready for a motion?
Yeah, Mr. Chair, I think I'm good for a motion.
Thanks.
I find the application meeting the 4 tests. Would like to move approval subject to the 2 planning conditions and 2 forestry conditions being 1 and 2.
Okay, thank you. So I have a seconder for that. Mr. Palmer, thank you. All in favor? You have unanimous approval. Thank you, Ms. Jin, and thank you, Ms. Redan. And we can move on to the next application. Item number 27, 18 Bell Royal Court. And it's an application for a detached dwelling with an attached garage. There are 8 variances. This matter was deferred from September 9, 2023. Urban Forestry looking for conditions 1 and 2. The matter for the deferral was in order to set out in the additional materials. We have the minutes to correctly identify the variances. It looks like planning advised that their previous report of January 26th stands. That was a construct as illustrated with respect to the building length and the front yard setback. And interesting, that was when there were 13 variances, and there's now 8. So let's find out how those variances got reduced, I assume, or perhaps, I don't know if planning was okay with the 13 or only after they reduced it. So let's find out from Giorgio Lolos, the agent. Mr. Lolos, you're the only speaker on this application.
Good afternoon, Mr. Chair, members of the committee, and committee adjustment staff. Giorgio Lolos, 220 Duncan Mills Road. Thank you for the time to present our application in front of us. Yes, correct, sir. Originally, we had 13 variances after we engaged with planning, and planning's original concern was the building depth. Now, truly try to recognize the existing lot characteristics. we have a little bit of a uncharacteristical lot in the start of the cul-de-sac. It presents a very, very difficult front yard sort of contour, and also top to back topographical conditions that are approximately, as far as heights, approximately almost 7 foot high. So we were faced with a bit of design issues that we felt that we did our best to mandate the owner's responsibilities and requests for families' needs. Planning's original concerns was with front yard setback, and of course, given the characteristics of the contours of the front yard, you can see how difficult it would have been to meet that. So we ended up at a comfortable sort of notion of 7.75 meters. They also recommended that we also drop our front yard pedestrian entrance to conform with that. With that, we lost 3 variances. That's why we sort of added on to it. Also, with that itself, by reducing the front yard setback, we took away the coverage. That's where the 4th variance was limited. We had no problems in this, as long as we maintained the certain conditions and requirements that the lot presented us, and we wanted to maintain, given with the lot characteristics, for example, the rear yard pool that the owners wanted to keep because of his grandchildren. And basically, in a nutshell, I mean, like, the homeowners are retiring. This is their empty nest egg, in a sense. They have presented their applications to the neighbors. Apparently, as far as we're concerned, the neighbors have no objections or no concerns. As far as we're concerned right now, we don't know if there's any letters. I didn't see the list reports. Other than the fact, I think the variances are minor in nature. I can go through them individually.
That's okay. I have a question for you, though.
Yes, sir.
So I'm looking at from the previous materials, the staff can get it up. You write them 21, and we had the revision all highlighted up. And
Yes,
then I believe we deferred in order to make sure the variances were correctly identified. So there's been no change. That marked up 21 with the revisions is basically what's before us. The reason I think we deferred wasn't to negotiate further changes, but to make sure everything was correctly identified. So
well, I believe, Mr. Chairman, the concerns was, yes, when I reviewed the current zoning review on February the 10th, it's identical to my waiver that I was forced to maintain that at a certain timelines. But I think it was a technical sort of misunderstanding on the clerical aspect as far as what was sent to the letters. That was misunderstanding there.
Okay, so this is what's before us now.
Correct, sir.
It's cleaned up. It's taken a few months. It's cleaned up. Made sure everything was okay. So basically, they were already okay with it back in January.
Correct, sir. Correct.
Their condition, which I assume you're okay with their condition.
Absolutely.
Okay. Okay, members, any questions for Mr. Lolos, or is someone ready for a motion?
Yeah, I'm ready for a motion here. Okay. I will recommend approval. Variances requested are minor in nature and meet the 4 tests in the Planning Act, subject to planning conditions and subject to forestry condition 1 and 2.
Thank you. Seconded for that.
Mr. Chair, the
Yes.
condition requests that they apply to certain plans, but those plans have now changed.
No.
You mean the condition from planning? So it should be based on this newly identified plans, correct?
Yes.
Looking back to their, because their email was back from the January 26th. So it talked as the site plan dated January 24, 2023. So what's the correct date to tie that to? He basically cleaned up the same plan, and he's off the line already.
No, Mr. Chair, I can bring it back if you'd like.
Mr. Lolos there, yeah.
Yes, Mr. Chairman.
Mr. Lolos?
Yes, sir.
Secretary Treasurer has a question.
Go ahead. Yes.
So the planning condition recommends that your application be tied to plans, but I think those plans are out of date.
It refers to January 24, 2023. Has that been updated, or is that still the correct date of the site plan?
Through you, Mr. Chair, Barb, if we can tie to if we just tie the plans that were submitted for the zoning review that was currently right now February the 10th, those are the ones that we're tied to. Also, planning did receive my revised plans before I submitted for zoning review. So planning does have the most current plans in play.
I know, but the problem is their email says their previous report still stands. Their previous report references old plans.
Well, I mean, in all fairness, Mr. Chair, I believe then we should just make the most current zoning notice review the primary candidate for the plans themselves, which they should have a plan, because we did submit to committee also, Barb.
You did, but your plans show older revisions. It shows January 20th.
As far as the last revision category?
Yeah.
Well, then it's probably our fault in our office are not updating our files. But I can assure you, without the most current plans, we wouldn't have gotten the zoning review that's currently in line today. It almost exactly identical to the waiver that I prepared.
I know. So the committee is trying to tie them to plans. How do they know which are the correct ones? Is the question.
Oh, good question. Now I am perplexed at that question, because I thought we did our due diligence.
The one that shows the
our
building length and the front yard setback. That's what they want it tied for.
I think the most current site plan that we have does show a front yard setback at 7.75 on the bottom right hand corner.
It's too fuzzy to read on my plan.
Perhaps we can just say to the satisfaction of the community planning department with respect to the variance requested for front yard and building length.
Sure.
Okay.
So I will revise my recommendation to tie the variances to the satisfaction of the planning department with respect to the variances requested for front yard setback and building length.
Okay.
And also subject to forestry conditions 1 and 2.
Yeah. Okay. So we had the seconder for that was, I think, Nishi, and all in favor. So, okay, we're done. And we have now properly identified. Okay, next application.
Thank you, Mr. Chairman.
Thank you. Items 2834 BERL Avenue. It's a detached dwelling with an attached garage with 6 variances. Was deferred from February 9th in order to correctly identify variances. We have supporting material. Oh yeah, we have many precedent decisions to go through. We have photos of 35 of new builds in the area. Very helpful. And then we have planning wants a condition of approval tying it to the plans. The speaker on this application is Eddie Perez. Welcome, Mr. Perez.
Hello, good afternoon, Chairman and committee members. My name is Eddie Perez at 537 Rogers, EKP Designs. If you have any questions, I'm happy to answer them. Thank you.
Yeah, you provide us a lot of support, a lot of COA decisions, and again, some nice pictures of nice builds in the area. So just one of those builds, you show 35 BERL right across the street.
Yeah.
Some very handsome looking homes. So you're telling us this is the prevailing character, and your new home is going to be similar to this prevailing character.
That's correct.
Okay. Yeah, some very handsome looking homes here. You're okay with the planning condition?
Yeah, I'm okay with planning condition.
Okay, so let's see if members any questions for Mr. Perez. Oh, there you all are. Any questions, or if not, is someone ready for a motion? And I don't think there's no urban forestry on this. Mrs. McCluskey?
Yep, I'll move to approve the application. Believe it meets 4 tests. That approval is tied to planning conditions. So.
Okay. Thank you. Seconder for that? Mr. Komorek, thank you. All in favor? You have a unanimous approval. Thank you, Mr. Perez. We'll see you again. Be well. And that takes us to our last application of the afternoon, 122 Ashbourne Drive. And this is an application to construct a new detached dwelling with an attached garage. And where's my fleets? Oh, here it is. We have 4 variances. We have supporting material with photos. Planning is looking for a condition of approval to modify variance 4 and a 1.5 meter privacy screen on the south side of the second story deck. We have opposition from 120. They're opposed to variance 4. And forestry is looking to deny variances 1 and 3 and advisory comments as well. We have also urban forestry 2 and 5 on the checklist. So the speaker is Jerzy Tomaszewski.
Mr. Chair, this agent is Dave Lang.
Oh, sorry. You're right.
Sorry, Mr. Chair.
Dave Lang, and the neighbor is Jerzy Tomaszewski.
Correct.
120 Ashbourne. My
Correct.
apologies. Okay.
And the area resident is present on the call.
Okay, thank you. Okay, Mr. Lang.
Afternoon. David Lang, agent for the application, 2100 Bloor Street West.
Okay.
I give you a quick presentation, maybe?
Yes, a quick. I do have someone here. We're not sure whether they're in opposition or what they're here, but just give us a brief explanation. You're okay with the planning condition, and just run through quickly the variances. This is the first. This matter is not a deferral. Everyone this afternoon after item 20 was, but this is the first time up for this one. Thank you. It looks like the neighbor's going to be opposed to the rear balcony variance, but we'll hear from the neighbor, I guess, in due course.
Yeah, there was I got a phone call from the planning department. They had some concerns about the size of the balcony as well. Asked us to reduce it and add a privacy screening, which we were okay with. That was the plan that we had sent back. Unfortunately, the owners are not in the country right now, so they have not had a chance to meet with the neighbor. We're hoping that the privacy fencing would possibly address their concerns.
Okay, David, this second floor balcony, which is allowed to be 4 meters and often comes in larger for squaring off purposes, is that off one of the, like a master bedroom for having a coffee? It's not a place where there's likely to be a big party.
No, it's very much, it's off the rear bedroom. It just happens to be a flat roof area that they created to have that balcony,
Okay.
not for entertainment purposes.
Right. Okay. And the fact that it's 11 meters and not 4.
It's been revised.
It's been revised?
Been slightly reduced down to 9.5 meters.
Oh, 9.5. Okay. Right. 9.5. And that's shown, it's squared off. I'm looking at the plan here. So on your second floor plan, it shows it's sort of like inset.
Yeah, there's just a flat roof area there that we had the whole balcony going over that area, but we've since reduced it at the request of the planning department.
Okay. And it's so it doesn't protrude out past the wall. It's inset.
No.
Okay. Just understand. Okay. Members, any other questions for Mr. Lang before we hear from the neighbor? Anything you'd like explained? Yeah, just the forestry conditions, sir. What's the situation we're looking? They want to deny variances 1 and 3, and there's advisory, and then they're looking for conditions 2 and 5.
Honestly, I was a little confused about the report. The tree they're referring to is a city tree out by the curb, and it's nowhere near the footprint of the house. I believe maybe they were referring to a private tree further back, which would actually be more impacted by the pool and the shed. So I have a phone call into the urban forestry department trying to sort it out with them. So it's definitely something we're working on.
Okay, so you would be okay if committee opposes conditions 1 and 2, or 1 and 2 and 3? Oh no, they were looking to deny variances 1 and 3, not 3. So urban forestry 1 and 2. Urban forestry, I guess, if you can just explain, if the tree has to be occasioned not by the build, but by the amount of the build that's in variance. So if the tree would have been affected in any case, even if you build as of right, then urban forestry can't complain about that. But here they seem to imply that your variance 1 and variance 3.
It's just odd because it's a city tree. It's out on the other side of the property. That's why I was confused about it.
Me too. Okay, members, any questions for Mr. Lang before we hear from the neighbor? Okay, Mr. Lang, stay tuned. We're going to hear from the neighbor next door. Mr. Tomaszewski? Mr. Tomaszewski?
Good afternoon. Can you hear me?
Yes, loud and clear.
Excellent. Thank you, committee, for hearing me. Again, my only concern is the size. Again, we've spoke, both Dave and the committees spoke in regards to size, as this is not an entertainment patio. The average size of a balcony for a condo is 3.3 meters square. This is 9.8 meters square. Minor variance between from 4 to 9 meters is more than a minor variance. I do appreciate that the builder has come back and put a privacy screen up. That is fantastic, but that would be my only concern, is that, again, I have three kids, and then everybody coming around, I'd be concerned just about the privacy going into my backyard, and the possibility of everybody blaring in. So from your point of view, again, I know there's minor variances or not, but it would that's what you're there for, guys, to help us out, right? So I'd appreciate looking into that.
So, sir, usually we like to look at where it is. If it's off in off a family room, this is off like the master ensuite. It's likely a place to just go sit, and it looks like it is inset, which is a real bonus. And often it's the size, like if you put up a wall and it says, oh, you can't go past that area, it's still intended for presumably 2 people, and they're unlikely to have parties there. So if it fits within this, some of this would look odd if it's made too small. You're right, the condo balcony is smaller, but it looks to me, which is very interesting with this one, in your benefit, it looks like it's inset into the building envelope and doesn't just stick out from the back wall like it often does, and they would be permitted to do that at 4 square meters. So if I was the neighbor next door, I'd rather have this situation with the 9.
I agree solely. Again, I'm just, it's a point of a minor variance, opposed to, minor is minor. Something over 5 is, I think, more than minor, right?
Yeah, but we don't, you don't look at the numbers, but I'm saying the fact that it's inset, I don't know if we have the plan up on the board for you, the second floor plan. It sort of is like set into the building, which to me, if I was the neighbor, I'd rather see that at 9 meters than a 4 meter one that juts out from the building wall. And that certainly allows for more overlook. Anyway, I'm not doing his job for him. I'm just saying, if I was you, I'd be happier with this than what he's permitted as of right. And I'd be concerned if it was off a family room or second floor family room or something like that, but it's off the master bedroom. So just my 2 cents worth. So anyone else have any questions for the neighbor or comments? Or if not, we'll turn it back over to Mr. Lang. But other than that, you're fine with this, Mr. Tomaszewski? Otherwise,
absolutely, it's a beautiful house, and again, makes for the neighborhood. So yeah.
Okay, Mr. Lang, if you want to respond, I've sort of responded just with my 2 cents. But,
no, I appreciate you expanding on that. I've just, if the neighbor is still there, I would encourage them to definitely connect with the owners when they're back in the country. They'd be happy to work with them if when they're actually doing the balcony part. But I appreciate you expanding on that.
Actually, so how did you reduce it from 11.3 to 9.5 or whatever you did?
We had it right out to the edge. So by pulling the railing back, the balcony is actually smaller. Okay. So you can't go like hang right off the side of the balcony, I guess.
Yeah. Anyway, it is inset, which I think is amazing. So, okay, members, any questions for either party, or is someone ready for a motion?
I'm just trying to clarify Forestry's position on this application, because there's like 2, I don't know, they're saying to deny or condition 2, but then in their other memo, it says they want condition 1.
Yeah, and the agent, so Mr. Lang told us that there's a city tree out there, but it said deny variances 1 and 3.
I honestly, it is confusing to me because they're referring to a tree that is literally out at the curb and nowhere near the footprint. And I'm suspecting there's a private tree in the back somewhere related to maybe the pool. Because
I believe there is, and I think that's why the original, like, there's the specific report, and then there's the general forestry consolidated memo. And in the consolidated memo, they were saying condition 2 as an alternative to denial, and condition 2 is a private tree. So that would lead me to believe that they're concern is both with a city and a private tree.
So I think they're providing advisory comments with relate to the tree in the back, and that they may not provide approval for the removal of that tree for the pool. The one where they're asking for refusal, I think that relates to the city tree because of the driveway and its proximity to that existing city tree.
Case we were going to work around the tree. The driveway would probably get tapered off as it made its way out to the curb, if that's what they were asking. I think I may have sent a sketch to somebody about that.
I take it your client would like to retain the city tree.
Right now, that was the plan, I guess.
So,
okay, so I think we can resolve this by including conditions 1 and 2.
Yeah.
On that spreadsheet chart that they have?
Well, no, I'm just on their spreadsheet, they're only asking for condition 2.
Well, I've got one that shows both. I think that's what you were referring to?
Yeah, well, they have they have a report that's specific to this application, which they're requesting condition 1, the city tree.
Yeah.
So I'm just going to incorporate both as you need to work with them on those 2 issues, and then we'll.
Yeah, it refers to a city-owned London plane tree measuring 11 centimeters. Protected. It's the street tree. But you're saying you're not going to be anywhere near that.
And that's fine. I think the concern was the privately owned tree in the back, and there's no details from forestry as to what that concern is. So, or is there? Hold on.
I believe that was in their earlier memo from January or something like that.
Yeah.
Where they were talking about a pool, and the pool is not subject to this variance application.
Right.
So they're saying the pool shed might require this tree to be removed or moved. So can you move the pool shed? Well, that has nothing to do with what's before us right now.
Yeah, it says that this memo says the tree impact of this tree is not directly related to the approval of the COA application of the applicants or the applicants as of right permissions. I think just an advisory, whatever. So
okay, so we can.
Yeah.
All right, so we're just concerned with the city tree then.
Okay, so we do have a memo, a motion on the table then?
Sorry, the motion then would be to approve the revised application, subject to planning condition requesting the 1.5 meter privacy screen on the south side of the balcony, and subject to forestry condition 1.
Okay. Seconder for that motion. Ms. McCluskey, thank you. All in favor? You have unanimous approval. Thank you, Mr. Lang, and thank you, Mr. Tomaszewski. And motion to adjourn. 5:18.
I'll move to adjourn.
Okay, thank you. Seconded by Mr. Merrick. And we're done. Thank you, staff. Thank you, Adam.
Thank you, Mr.
for
Chair.
moderating.
Thank you.
And, thank you to all the staff and all the members. So we'll see you all next time.
Thank you, everyone.
Thanks, Michael.
Bye-bye.
Bye, guys.